All right, let's get into this presentation. So I wanted to be a little bit creative here. And I wanted to check in since like AI is now the we're all trending in this direction of AI. So let's have some fun with it. I'm going to talk to Chat GPT and see what we can come up with and ask some questions about the Karen Reed case. So I wanted to do kind of this compare and contrast to Lally versus Brennan, and then I'm going to have a little bit of a extra at the end for everybody. But I think we can navigate our way through this. I when I did this, I said this is going to be one of my worst live shows that we're ever going to do, and people are going to hate me, or we can turn this into some pretty good content. I think we can turn this into some pretty good content here. So let me bring up my presentation. Let's do this real quick. Olaf, thank you for the 2, says Norfolk DA, all hat, no cattle. I love that. That's really cool. All right, so we're here for the weekly wind up, and what I wanted to do was let's just play the game. Let's ask Chat GPT and see what Chat GPT has to say about the Karen Reed trial, essentially according to comparing Adam Lally and Hank Brennan. We don't have to spend every waking minute on all these slides, but maybe we can pick and choose what we want. So I got a little bit of the background here. I'll just read some of this out for everybody. So Adam Lally led the prosecution in the initial trial, which concluded, but with a hung jury. Observers noted his methodical and thorough presentation, particularly in handling direct examinations of approximately 70 witnesses. However, some critics emerged regarding the delivery and engagement of his arguments. For instance, discussion on platforms like Reddit highlighted that while Lally effectively addressed the defense's conspiracy level theories, his focus on disapproving alternative narratives may have overshadowed the core evidence against Reed. Additionally, his closing arguments were perceived by some as lacking potentially in diminishing their impact. Okay, I'll open this up to the table. I don't agree with any of this. I don't agree with any of his methodical and thorough presentations. Someone help me out here.
Todd, I'm happy to take it first. Please, me.
Go for it. You're sitting there like Horseshack. So
yeah, I totally am. I was a teacher's pet. So okay. so first, let's obviously the audience knows AI is an interesting beast, and to some degree, it kind of soaks up little pieces of everything and then tries to make sense of it. Okay. But as far as Adam Lally is concerned, I'm going to start off by saying this, and I may make a few enemies when I say this. I think I'm going to start with the end. Lally put on a better case.
I think so too.
And I'm assuming the Commonwealth is going to rest this week. So let's assume there's nothing much more exciting that's going to move the needle. So now that you all know where I end, which will come through during tonight's stream, Lally, he's looking like a bright, shiny penny to me. There were plenty of things that I don't like about him, and I didn't like about his presentation. I mean, the what if anything, the guy has to go to some ATLA courses or seminars, which is the American Trial Lawyer Association, which really does offer great seminars on how to ask questions in a non-leading manner. He also put on every single witness under the sun.
Mm-hmm.
But in parentheses, we like that. We like that. And I heard this said by, I want to say it was Ian Runkle the other day when he was talking to Bettero, and I completely agree. By having 1.0, and now with the retrial, Lally put on every single witness. He needed to pare down the case.
He did.
But by putting on all of these witnesses in a pretty good order, I might add, he was able to give us and the world, the news media, content creators, the bigger picture. So now we know a lot of things that the Commonwealth is hiding through Brennan. For example, we know what Brian Albert's going to say. We know what Brian Higgins is going to say. Proctor, you name it. Whomever you think should have been called by the Commonwealth, Lally called them. So we know that information, and it was helpful, and it is helpful to help frame discussions about the case or what's being hidden and what we know is coming from the defense. And I'm sure it also kicked off really robust investigation, further investigation by Karen and her defense team. But all in all, I think this AI description of Lally during the first trial, it's probably like putting lipstick on a pig, so to speak. Pardon the pun. But I do feel like overall he's better than Brennan is. Which, just wait, I have plenty to say about him.
Todd, any follow-up?
Yeah, I agree, Nan. With Lally, he presented a case that really turned over a lot of rocks. There was a lot of discovery that needed to happen. He provided that level of that window to the exposure of different things. Um, you know, he's cute like Brennan, right? If that federal investigation wasn't running in the background, we'd really be at a disadvantage. But the fact that he did call his full list of witnesses, or at least it appears that he called the full list, I think it set the defense up very nicely for trial 2.0.
Yep.
Yeah. All right, let's do a quick one on Hank Brennan. This is the AI description. For the retrial, the Norfolk District Attorney's Office appointed Hank Brennan, a seasoned attorney known for his representation of James Whitey Bulger. We need to stop right there. We got mob ties already. Brennan introduced a more assertive strategy, emphasizing forensic evidence and utilizing multimedia presentations, those stupid clips, to reinforce the prosecution's narrative. Notably, he incorporated video evidence of Reed's own statements between witness testimonies, a tactic praised by some legal analysts, and effectiveness in engaging the jury. Well, essentially why he's doing that is because they know that Karen Reed's never going to get up and testify, and they're using this to cut all these little clips up out of context to put it up there to the jury that, she's essentially, these are her words and she's testifying. And I don't think I think the jury's like, what is this? Another clip again? Like, they're probably not even paying attention. But anyway, however,
Yep.
Brennan's approach has not been without criticism. Some commentators argue that his initial presentations lack clarity and failed to captivate the audience. For example, an article from Howie Carr, described Brennan's opening as putting a worldwide audience not just to sleep, but into a deep coma, suggests that his delivery may have been less compelling than anticipated. I'm going to start with Todd on this one. Todd, what do you think?
Yeah, I think he's a snake in the grass. I don't like his approach. He's a guy that is coming off as, Mr. Reasonable. I want the defense to have the most rigorous defense, but yet you're hiding Proctor as part of your strategy. So, if you want to call things straight, then bring all the players back to the table. Put everybody in that witness stand and let them have their chance in the defense to be able to cross. So, his strategies are just angling, and the way he's going about doing it is what I would say equivalent to a snake in the grass.
Yeah.
Nan, follow up.
I think so. I agree with Todd, and I think that some of that description was a little inaccurate because Brennan is not. I wouldn't criticize how he's presenting what he's presenting when he's presenting it. Like, people are kind of saying, or AI was saying, it kind of falls flat. I think the biggest critique of Brennan, besides the fact that he has put forth this broken-ended prosecution, is that he doesn't believe the story. He doesn't believe the narrative. So when an attorney, and it happens, attorneys sometimes have to argue causes that they don't believe in, or where, as I said before, the law or the facts are not on their side. But if one of the things they do teach you in law school, and then it carries throughout your career, is you have to learn to be convincing. You have to learn to almost fake that you believe in something. So when that lack of belief does not exude through what he's trying to present to a jury, what he comes off as is a sniveling idiot. I'm going to reiterate here that I stand by my long-standing opinion that he is a complete idiot. People call him cunning. I think AI called him, or somebody called him cunning. He's not cunning. He's a dirty street fighter who hides the ball, who, when faced with challenge like ARCA or ACA, as you guys say, he'll do that gaslighting that I was referring to and what Todd was referring to, which is, I want them to have this. They should be having this. But then, a couple of weeks later, he's like, no, I want to completely bar ARCA. Also, I think one of the key problems with Brennan is that when he is asking questions, he will save for his rebuttal. So he'll go through his direct, then the defense does their cross, and then he'll save new things for rebuttal as if these are like zingers that are going to land, and they don't land. And in fact, when you try to hit in your rebuttal, which by the way is only supposed to be limited to the scope of cross, so it's put on your direct, then there's the cross-examination, and the rebuttal isn't your opportunity as a prosecutor to then throw new things in. You're supposed to limit what you bring in on rebuttal to the scope of the cross-exam.
Mm-hmm.
And when he tries to come in on the cross, he brings these alleged zingers and they completely miss. He doesn't get it. And in fact, it's backfired for him at times. Suddenly it's you're getting witnesses to make concessions that completely undermine your case.
Yeah.
So that is the nicest way I can critique him. But I think he's a horrible attorney. I think he's a complete idiot. And these opinions are my own.
Wow, wow, wow. That's fine, Your Honor. They want to talk about ARCA. I'll welcome it.
It's the best impersonation on
God.
YouTube.
So real quick, legal strategy. This is what AI spit out. Adam Lally focused heavily on disapproving the defense conspiracy theory, including questioning the credibility of key defense witnesses. He brought his case by methodically presenting physical evidence and relying on direct testimony. But his strategy was seen by some as too reactive, trying to negate the defense instead of strengthening the prosecution's core theory. Then Hank Brennan says has taken a more proactive approach, emphasizing forensic and scientific evidence such as blood pattern analysis and digital location data. He's using a narrative-first strategy that aims to tell a story, integrating video clips of Reed. Oh God, so corny. Timeline and visuals to make the prosecution case feel more coherent and persuasive. Verdict: Brennan is seen as more narrative-driven and trial savvy. Lally is more procedurally precise, but potentially less compelling in the big picture. We move on. Go ahead, Todd.
Yeah. So what ChatGPT missed is the inadequacies of the investigation. So it's saying how Lally brought physical evidence in from a flawed investigation. You have a crime scene that was lifted. It's contaminated. You've got evidence collection happening over a period of several days. You've got evidence that was held back and not entered into chain of custody at the crime lab, which there was zero reason for that to ever happen. So there was just a number of things. I tend to rehash and go back to all these other things that we know and love and what we've learned. But it's just both attorneys, Lally and Brennan, had a horrible case that never should have gone forward. And here they are trying to make lemonade out of lemons.
Yeah, I go to this super chat and I'll say this one for you. It's kind of like putting 10 pounds of what shit inside a 5-pound bag. That's what this case is. Katie checking in for a $5 super chat says, "Hi fam, thank you for supporting Karen Reed. Bev is biased. We all know Brennan is actually smart and knows he can get away with this all. Bev is the problem." Well, the jury will decide. But I'm feeling pretty good so far. So communication style and jury engagement. Lally, formal, composed, and restraint. Qualities that helped maintain courtroom decorum, but may have come across as stiff and uninspiring. I love that. That's pretty perfect there. His closing arguments were clear, but not memorable, according to some trial watchers. No, I don't think they were clear at all. Brennan, more animated and confrontational, sometimes borderline on theatrical, uses multimedia to drive points home, and occasionally employs sarcasm and rhetoric questions, possibly to resonate emotions with the jury. Verdict: Brennan appears to have the edge in jury engagement and courtroom drama, though some feel he can overplay his hand and appear overbearing. Whoever wants to tackle this one first, Please
Yeah.
jump in.
Please, I will. So I think that we can all agree that Adam Lally has the personality of a sack of flour. He's just not engaging whatsoever. And believe it or not, I'm going to throw him a compliment. He's actually not bad on cross-examination. If you all look back, just watch any defense witness who was being cross-examined during 1.0. He's not that bad at cross-examining. And it predominantly stems, in my opinion, from the fact that he sucks at asking non-leading questions. So when he can lead during cross-examination, he has a little bit more zeal for what he's asking. But he's flat and boring. He's not engaging. I never saw how the jury reacted to him during 1.0.
I did.
Did you? What, were they awake?
No, and it was weird because they were sleepy. But then when when AJ got up there, I mean, they played this
the old
match.
I saw that going on last
It's
week.
the tennis match, Yeah. But it's like when he was up there, they were like back like this and drifting off, and maybe someone might have been scribbling in their notepad. I mean, they're not paying attention. So I've got to see it in both trials, which has been pretty interesting.
And part of that stems from not only his style, but Adam Lally's just he did not pare down his case very well. So he was asking about, what music was playing and what's your social security number and your size of underwear. So I mean, he was all over the place. I believe, Adam Lally, here's an offer to you after the trial. If you'd like to reach out to me, I'll teach you how to be a good trial lawyer.
Oh,
if you still have a job when you're done. But as far as Brennan is concerned, I don't agree with AI on this one either. NG says that while he's certainly more interesting to listen to than Lally, Brennan is his voice is like nails down a chalkboard, which you've mastered, Brian. He also comes off as a petulant child, especially in rebuttal. So when going back to what I was just saying before, when he comes in and he starts with his rebuttal, and you were told this, weren't you not? And if you didn't do this, you would do this, right? And it really irritates the jury. I saw it firsthand. And if you irritate a jury, you could be right on the facts or the law, or the facts and the law. But if you lose the jury in terms of your personality, your panache, and your finesse, you're done. So both of them, they both suck. I mean, it's like a net loss for them. I will say, though, that little last bullet on the AI slide there about the verdict or what it was perceiving for a verdict, there's going to be an acquittal. I'm calling it now. She's going to be acquitted. I cannot fathom that this is going to be a mistrial. I know I disagree with a lot of law tubers when I say that, but ultimately, even if you can't find 12 to convict her, what the Constitution and the state laws say is that if you can't all convict her, if you can't all find her guilty beyond a reasonable doubt to a moral certainty, it's not a mistrial. And that's why this jury in 1.0 was so misguided, misinformed, and mischarged by you, Canoni, that they should have had a mistrial. So assuming there's no plans on this jury, which, the jury's still out on that one, they should acquit her.
Let me just comment here, and I'm going to go to Todd for a follow-up. For crow's sake, they have Commonwealth witnesses saying there's reasonable doubt to this. I mean, the slip and fall, Klopek. I mean, I mean, that just Brennan must have been sitting there in his head going, ah. I mean, this is happening and unfolding right in front of his eyes. Todd, any follow-up on communication style and jury engagement?
Yeah, just we saw mostly during the hearings before the jury was introduced into the trial, just the theater that Brennan would put on, and that's risky. And we haven't seen him do it yet, as far as I've been watching in front of the jury. That's a very, very dangerous proposition if he tries to grandstand like this. So to Nan's point, if he hasn't lost them already, he will.
Yeah,
I love it. I love it. Before we go to the next slide, if everybody can do this for me, just smash the like button down below. It's free. We want to get some more people in here and maybe some new subscribers because YouTube really reacts to that like button. If we can get over 1,000 likes by the end of the stream, I'll be super duper duper happy. Okay, witness examination. Lally conducted nearly 70 witness examinations in the first trial. He was methodical and detailed. It's kind of a repeat here. Some critiques suggested he had been more focused. Some examinations were lengthy and meandering. We had Brennan, his witness questioning are more targeted in attempts to control the narrative more tightly. He interpurses witness testimony with video and audio clips aiming at trapped inconsistencies or adds emotional weight. And the verdict to this is that Lally wins on thoroughness. Brennan excels in impactful cross-examination and pacing. I don't agree with any of this, and I think we kind of covered it in the last segment, but if anybody wants to comment, if not, we can move on to the next slide.
You know, I have to say, Brian, I agree with this slide a little bit. I do a little bit.
Okay, tell me why.
Just because, you know, with Lally, he overplayed his hand, called too many witnesses. So I don't want to repeat, but
okay, I agree there.
Okay, lengthy, boring testimonies. Brennan is more restrained and edited in his narrative. So he's very targeted what he wants to achieve. I'm not saying he's good at it, but he's definitely pared down the witness list. He's telling the story in a horrible order. But if you're going to look at witness examination and how he examines witnesses, other than the fact that this has backfired for him, as we were discussing, I think that's a pretty accurate description of how you're to compare the two. Brennan is more focused and targeted. Lally is, as my late father would say, he's a lost fart in a blizzard. But as far as ultimately, I think a jury would respond better to someone like Lally, even though he's bored them. He's at least telling a story in an order and a fashion that can make sense to them. And the last point I would make just on the audio clips, which I know it was mentioned on the slide, these audio clips they're a disaster for the Commonwealth. Besides the fact that I can't believe the judge is allowing them in, there's things called rules of completeness that I don't know if the defense is going to invoke it, but if you're going to show part of something, the rules of completeness say that you have to show, or you have the ability and the right to show all of something. So I'm interested to see if the defense is going to go there and show more of the contextual environment of what was said around these clips. But I looked at this jury. I know you looked at this jury, Brian. I don't think that they are dumb enough to think that a little 17-second blurb is going to
move the needle.
The day. Yeah.
Move the needle. Yeah. Todd, any follow-up?
I would just add that I think Brennan did a horrible job in prepping his witnesses. He would throw out the bomb question, thinking he was going to get a slam dunk, and you get someone like Scotty Bellows saying, "I see no evidence of any type of impact or any type of injury to be consistent with the collision." So that's just one example of many. And so if you're not going to get that slam dunk response, why throw out the question?
Agreed.
I just think that it's going to be a complete disaster in the sense of if the Commonwealth rests this week, let's just say that they do. Okay. They got apparently 3 more witnesses I'm hearing that they may call. Crosby, Welcher, and I forget the other witness.
Crosby might be on rebuttal from what I now understand, but Welcher.
There's another expert they're going to call. I think another data expert.
And
they may call Guarino back, right?
I heard they might call Guarino back. I heard that they might call Flamati. He's like one of the paramedics.
Flamati. Yes.
Yeah.
Here's the issue. You haven't called the homeowner and tried to save that.
Yeah.
You haven't called Brian Higgins, and he's been introduced into this. That's going to be disastrous because the defense is going to call them. And the first question that's going to be asked to Brian Albert, and it should be the first question they ask, is You live at this home where a Boston police officer is dead and dying on your front lawn, and you have literally the brigade rolling in with
Right.
lights, and I don't know if there were sirens that night, and you have all this commotion outside, and you don't come outside at all? I mean,
Yeah.
after hearing everything that you've just heard that has really literally crumbled, I think, horribly this time around, even more worse than the first time in trial 1, but now the second trial, things have crumbled even worse, and you're gonna be prepared for that? You think that that jury is gonna buy this? And going back to your point, Dan, about storytelling, you think that jury is gonna buy that now? Like, "Oh, I was just sleeping. I couldn't hear anything."
Yeah, I agree with this wholeheartedly. And one of the best lessons I got as a baby lawyer was build the jury's trust. You are living a trial, and trials usually don't take this long. They're usually pretty quick. We've seen, even while Karen Reed's matters have been pending, we've seen other trials come and go. They're usually much more economized than hers have been. But with that said, you're with that jury exclusively for X period of time while the trial is going on. And you have to, from minute one, build their trust, whether it's setting their expectations, and that goes to the Commonwealth and the defense. What is the evidence going to show? Then you're to bring the witnesses, fact witnesses, and experts in to show that what you told the jury actually was truthful. And you, in a nice, cohesive fashion, then what you do is through your arguments, and first how you're questioning witnesses, and then through your closing arguments, you tie it all together. And when the Commonwealth refuses, why, I don't know, it's better to face the bumps and bruises. The judge I used to work for used to say, let them see you, warts and all.
Mm.
And let them see that I'm not so afraid of Michael Proctor. Is he a jerk? Yeah. Is he a lech or a cuck, as you guys like to say up in Massachusetts? Is he all of these things? Yeah, he is, but he's a damn good investigator, which, excuse me, I'm sorry, I'm making myself laugh. I can't say he's a damn good investigator in jest. But anyway, you have to face those bumps and bruises. And by not doing that, you've lost a jury's trust. I
Mhm.
hope that whomever closes really capitalizes on that, whether or not they call these individuals or not. So while I think they're going to call Proctor and Higgins and Brian Albert, and
Have
maybe
to.
I truly believe those are the three that they absolutely have to. There's others who they could, they should, but those are the three they absolutely have to. Um, I do believe Lucky Lawfren is on that list, but
Yeah.
that was, really not part of my analysis here.
Yeah.
But
Yeah.
when AJ closes, or Yannetti or whomever it is, they can say, even if they didn't call them, did you notice that the Commonwealth never put Michael Proctor on the
Yep.
stand?
There you
Did you
go.
notice that you never heard from the homeowners or Nicole Albert? You never heard from this. They're allowed to
Yeah.
say that.
Yeah, that's
And that
bad.
helps undermine the trust
Yeah,
issue or the trust deficiency.
I agree.
I'm
Todd,
going to
any
double
follow-up?
down,
Yep.
and I'm going to double down on what you just shared. This trial brought out a lot of data, a lot of very scientific information, the process between
Right.
timelines and cell phones, and the black box from the Lexus, and all of these different things. But to Nan's point, it's going to be the fact that you hid the lead investigator and this is what I'm saying about prepping Brennan not prepping his witnesses. The line of questions that he would throw out there: whose signature was on this form? Michael
Yeah.
Proctor. Who
Yeah.
presented this evidence? In the Michael Proctor.
Like a
And it just
proctor.
went on and on
Yep.
and on and on. And I would think that the jury would be like, well, what? He's part of this case. Why would you hide him? Right. So you're looking at me as a juror that I can't process this information however it should be presented. What
Right.
I respect with Lally is that it was a rip the Band-Aid moment. You brought Proctor in. We know what the damage is going to be. Let's just get it over with, and then whatever happens from there happens. But to play the jury for fools and not bring Proctor in at all for 2.0, it's going to be detrimental to the case.
Completely agree.
And it's now, you know, and you've been hearing it throughout the trial. You've heard Trooper Michael Proctor, and then you've heard Michael Proctor. So that's probably the jury's going, okay, what's going on here? Because they don't know all the details that he's been fired. I wonder, can that be brought up in the defense? Could they say that in their closing statement, Nan?
That he's
Or
been
they,
fired?
yeah.
Oh, yeah.
Okay.
Yeah. It might have been different if he were fired for, years back or disciplined years back for unrelated reasons. There's case
Okay.
law that talks about that perhaps would have to go through a judicial challenge to get that in. But he was terminated partly because of this case.
His
The
actions, right?
bias.
Absolutely.
Yeah.
Yep.
So it's coming in.
Oof,
And
it's gonna be
honestly,
disastrous.
like Brennan's not even mentioning that.
Yeah.
He's not.
Defense is gonna
Remember, I want everyone to remember what I said tonight about trust. Remember that when an attorney loses that trust in the jury and vice versa, it no longer becomes a cooperative mission to get to the justice that is being sought. And by the way, to all the trolls out there, you should care about that, because you keep saying this is justice for John O'Keefe. Well, to get to justice, you need to get to the truth. And in supporting Karen Read, which I do, I'm not speaking for anybody else when I say that, although I have a feeling I know where my fellows lie on this. But where I get to justice for John O'Keefe is to vindicate Karen and to vehemently speak out against sham prosecutions.
Mhm.
And that's what this is.
Yeah. Kangaroo court all the way.
Yeah.
Kangaroo court all the way. Let's just take a quick pause here. I want to answer some of the super chats. We'll get those out of the way, and then we'll move on to the next slide. But I do see a chat in here that I want to address right now. Someone's asking me, FM is asking, what happened to the justice for Enrique? Not hearing much from you about that. All that I can say about this is it is an absolute ongoing investigation. There's been some mainstream media reports out there. I'm going to tell you, my sources and communication with the family has pretty much slowed down. I think they're just in a waiting game, just like we all are, as we've been waiting in this. And I've been trying to tap into my resources throughout all of this. And there's just not much information. This thing is about as tight as a snare drum, is what I can say. And that's really all I know that's out there, that's been put out. I think WBZ just had an updated report, and I've written some articles on my website as well, and you can check that out at ltlmedianews.com and get caught up. There's an Enrique tab. You can just click on that and read all of my writings on the story. So that's really where we're at. I have not forgotten about him. I understand that it's been 8 months since that incident happened at the Mass State Police Academy in New Braintree. My thoughts are with the family and with him every day. I still write about it. I still tweet about it. I still tweet at the Mass State Police, and I still tweet at Governor Healy to come to some kind of conclusion. But these things do take time, and I know it's very frustrating, but I want to let everybody know I haven't forgot. I know certainly Todd McGee has not forgot. Nan has not forgotten. We've had conversations about this, but there's just nothing at this point. So we'll just have to honestly just see what happens. I wish I had a better answer. I wish I had a better answer. Go ahead, Todd.
I would encourage everyone to just wait for the investigation to get completed. There'll be so much to talk about once that investigation is released. And I've got the highest regard for David Meyer and his team. They're going to do a thorough job for us and for the family, obviously for the family.
Yeah, and having some conversations, I'm feeling a lot, better about it. I was on the edge about it at first, and the the sources have come forward to me and things that I've heard. And again, you can read all about it at LTL Media News. Just click on that Enrique tab, and you'll get caught up to what I know about this case. But let's get to this real quick. Christy, thank you for the $10. Says, I pray that the defense calls Proctor and makes him read all those texts and admit that he had only that his only suspect was within hours. I pray that they call Brian Higgins and Brian Albert. I want them to finish the Commonwealth. No mercy. I love that that super chat. Thank you. We have Jackie. Thank you so much for being a member for 12 months. Standing in solidarity from Toronto, Ontario, Canada. Thank you so much. Norman Corey, $5, says Hank has wrapped this whole case around the trigger that happened while in the state police, proven by basic math. I can't believe we're still talking about 1162.
Yeah.
Another $10 super chat. Thank you so much. Brennan comes off as a whiny, spoiled child who's always gotten what he wants and is never reprimanded. He's not smart. In my opinion, he's slimy and has no moral compass. It's a great chat. It's a great chat too. V Caster, $10, says, how much is Spanky allowed to prep for Welcher? This would be a good one for Nan, because I'm convinced that he will have. Will you be interested? Love Brian, Nan, and Todd. Red lip tutorial, Nan, please, and thank you. Nan, if you want to speak to that real quick, and we'll move on.
So Hank is permitted to prep Welcher all he wants. Welcher is his expert. I imagine, well, I don't know when Welcher is going to be called. I keep hearing people say it's tomorrow morning, but Brennan is allowed unfettered access to him to prep him, and he's going to. I don't know how he's going to effectively prep him because Shannon Burgess shit the bed. But at this point, Hank's going to pull something, and I'm sure I'll be all over Twitter barking about it.
Oh, I'm sure.
As far as red lips, feel free to message me on X or on my La Furio Facebook page. I have it all typed out. It's 5 different things. Thank you.
All right.
If you want it, Todd, I'll send it to you too.
Reality check, $5. A question for Todd. Sir Todd, what are your views on the Mass State Police reform after this case and SB? Should it happen, and how?
I like the reforms. I think this is something that the department is embracing. You have a new colonel that has marching orders from the governor. And so, the fact that they had a review, they didn't have an audit of the police academy. There was a review that was released in the form of an RFP. Some contractor, took the contract and went in and did the review of all of the state police, not just the curriculum, but the state police culture as well at the recruit level. So I also, part of this reform is data collection. So we're going to see a ton of information that comes out of this class, out of how the recruits perform during the course of the academy. And so once all that stuff is released to the public, again, we'll be happy to talk in depth about what some of those different pieces of information that have surfaced come up.
Yeah, we'll be doing some follow-up shows, so stay tuned to that. Todd and I have been talking about that, off stage, and we're going to have some shows coming up pretty soon. Glamasus, thanks for the $5, says, Nan, do you expect a motion for a direct verdict at the end of the Commonwealth's case?
Hey, Glamasus, I do, and I always expect a motion for a directed verdict at the end of every Commonwealth case. But yes, there will be one, and it will be denied, unfortunately.
Charity, thank you so much for the 20. She says, I watched a channel I typically align with who recently started the Karen Reed case, and I was shocked. Was on the guilt side of a former PD. I was amazed by the panel's narrative of the Free Karen Reed points, lawyers, and take on the trial. Delusional. V Caster, thanks for the 5. Edit. I meant to say, how much can Spanky prep Welcher about Burgess's debacle? Oh, here we go.
I'm
Welcher's
sorry.
data predicated on Burgess' report, right?
Sorry, V Caster, I'm a blonde. I might have missed that nuance in your question. So Brennan can prep Welcher as much as he wants about Burgess's debacle. By the way, I love that word. There will be strategizing going on. There will be, I'm not saying this is proper. Well, an expert's opinions should be an expert's opinions, but it's Brennan. So, grain of salt. Brennan's going to try his very best to fit a square peg in a round hole and try to suggest things to Welcher to try to take the edge off of the fact that Burgess had, really serious deceptive misrepresentations in his credentials and qualifications as publicized not only on his own and on his personal, professional social media and on Aperture's website, but also just the fact that Burgess is a wholly underqualified expert. And frankly, he's the only thing I think Burgess is an expert in is not achieving a Bachelor of Science degree. I mean, he's very, very good at, after 17 years, not finishing one. But with all of that said, there will be some soft shoeing of what you'll see from Welcher to try to explain it away. But bigger picture, and I think it's important for everyone to realize this as we're in the wake of Welcher's testimony, all of the bad things that came out through Burgess, they are imputed to Aperture. Aperture either employs or contracts with or engages Burgess as an independent contractor or an employee. And you can't just hold Burgess out on the side and say, oh, okay, you know, he misrepresented his qualifications. No, they're adopted by Aperture. So there is going to be some tough questioning that's coming Welcher's way about the qualifications and the deceptive practices of advertising those qualifications of Burgess. In addition, I've seen on Twitter recently, there's some questions that are arising as to Welcher's qualifications.
Ooh.
Yeah.
And I was just going to ask, is Welcher Burgess's boss?
That's what it sounded like.
What's that, Todd?
Sorry,
It
Todd.
sounded like he was acquiescing to Welcher, that Welcher was kind of the higher authority.
Yikes.
Yeah, my understanding is Welcher is or may be the executive vice president of Aperture.
Ooh.
And Burgess is, you know, a lowly peon as far as I'm concerned. But boss may be a little bit of a stretch, but we would consider that in the law, and it may come up this week as principal agent. So Aperture is the principal. The officer of Aperture, meaning the executive officer, vice president, if he is the vice president, is Welcher. The agent is Burgess. And there's a ton of case law up in Massachusetts that says the acts of the agent can be imputed to the principal, which would be Aperture. So you may hear that pop up this week, and, you know, just consider yourself better informed on the subject.
Phew. I think they're going to have some real problems. I'm going to tell you, someone's probably going to get fired after this trial, or a few people might get fired. Let's just buzz through the rest of these. I do want to get back to the slides because I think this is going really well. Scooter 54 $10 says, I'm not sure if this has been answered. Are witnesses like Brian Albert, Brian Higgins, Michael Proctor going to be called as hostile witnesses by the defense? Yes, they most likely, and we did answer that, will be called by the defense. They have to. They have to. They're the three that have been introduced but kind of talked around, and the jury's going to go, who the hell are these people? And then when the defense gets up there, they're going to shred them. Absolutely shred them.
Just a little point on that, Brian, though. I think he was asking if they're going to be hostile witnesses.
Oh, okay. I got you.
But that's up for grabs. I forget the name of your chatter there, but they will be called in the defense case in chief, Scooter 54.
Yeah.
If they're giving evasive answers and they're not getting to the heart of the question asked, then the defense has to make an application to hold them as hostile witnesses so they can be cross-examined. And, you know, your guess is as good as mine if Canoni will allow that to happen.
Yeah. Leanne M, $2 says, hey, Nan, can the defense ask for a what is this? Sir butt dial?
Sir rebuttal.
Thank you. I looked at butt dial. I thought it was butt dial real quick.
Yeah, I was actually, and I know Leah probably saw that. I answered it in your chat. But yes, they can ask for a sir rebuttal, but, you know, you've got the Bev Canoni factor. So
I literally thought that said butt dial. I was like, am I reading that right? Is that butt dial? Mary, thank you for being a member for 2 months. It's a disgrace where we're doing for Karen Reed. Thank you all so much for helping her, supporting in Florence, Kentucky. Kentucky checking in tonight. Thank you, LTL and guests. I appreciate that. And let's do this last one, and then we'll get back to the slides. Ashley says, do you think that Bev would have grave concerns if someone on the jury lied to get on the jury and had no grave concerns about Burgess?
Yeah, the answer to that is yes. That's a very fair question.
Yeah, absolutely. All right, so let's just bump down. We'll go to the overall comparative summary here. So we look at a couple categories: strategy, jury engagement, witness handling, public perception, trial outcome so far. You have Adam Lally. This is a scorecard, Nan. This is a scorecard.
Yeah, it is.
Adam Lally, procedural evidence focused in jury engagement, professional but flat. Witness handling, meticulous but slow. Public perception, respected but subdued. And then we have the trial outcome of hung jury. And then we go to Hank Brennan for strategy, narrative-driven, confrontational, jury engagement, dynamic, sometimes over the top, witness handling, tactical and visual, public perception, mixed as seen as a fixer or a showman, and then trial outcome. So far, obviously, we're pending trial. I'm going to go to Todd first on this one. Todd, what do you think of this overall comparative summary between Brennan and Lally?
Well, chat did its best, so we can a grain of salt. Again, different styles, in we'll see the end result. Canoni gave the Commonwealth a second bite at the apple where this should have gone to a verdict, and we'll just hopefully everything stays intact so we can get to deliberations for trial 2.0.
Yeah, I don't actually. I think it's pretty there. I mean, I think it's pretty much on. Nan, how are you feeling about this overall comparative summary?
I think it's
It's
pretty
not
accurate.
bad.
It's not bad. I mean, by no means, I don't like Brennan. I did not like Lally, but it's kind of like when you realize you don't realize what you had till it's gone. Like I miss Lally now. I happened to walk into court right behind him the other day, and I wanted to just come up behind him and say, "It's gonna be okay. It's gonna be okay." But I didn't. But I do feel that was pretty accurate scorecard. And the only overall additional critique I would give, Brian, is that it is probably glaringly obvious to the jury that the unimportant witnesses are being questioned by Lally. So like when Lally asks questions of witnesses, it's like this unintended signal to the jury, like, this witness doesn't really matter. So they probably turn off a little bit. I do feel though that Brennan is not, he's just not a likable guy, and it exudes from him down to his facial expressions and his lovely voice as you imitate. It's just not going to land well.
Yeah, I agree. It's not a bad summary. I think the AI caught it pretty good. All right. Well, we talked about Lally, we talked about Brennan, we gave the strength and weaknesses, but of course we cannot do this without, because if I didn't do it, everybody in the chat would kill us. But wait, there's more. And I asked ChatGPT about the defense. We had to add this in there as well. So we had a little fun with the defense, and we'll go through these few slides here. So ChatGPT says the defense strengths, effective use of expert testimony. Dr. Klopek testimony gave jurors a credible alternative explanation for O'Keefe's injuries, fall versus car strike, which undermines the prosecution's central claim. And then we go to the digital forensic. Digital forensic experts argue that John O'Keefe may have been inside the Albert home, not left outside by Reed. This contradicts the state's entire timeline. We have number 2, attacking the investigation. The defense has put on credible law enforcement. The defense has put the credibility of law enforcement front and center, especially by hammering misconduct. And here it is, by Michael Proctor. Racial slurs, text messages, and being dishonorably discharged. Some of that's a little muttered by the AI, but the feeds, and then it goes, this feeds the narrative that Karen Reed is being framed, at least that the investigation was so flawed it can't be trusted. And we have the narrative control. They've done a strong job planting plausible alternative theories, specifically that the fatal injury happened inside the house and not from a hit and run. And their media savvy team has helped shape public sentiment, and in the courtroom, they have played into the energy by keeping the case human and emotional. I'm going to go to Todd first. Todd, your reaction on the defense strengths according to the AI?
Yeah, I think ChatGPT did well on this one. I was sitting here as you were reading, Brian, in more of Brennan's witnesses had a chance of being impeached by the defense. And you're not going to see that the other way around. I just, going by the first trial, all of the defense's witnesses that they called were so strong in their testimony. And, it was a much shorter list. So, we didn't have to listen week after week after week like we did with the Commonwealth. But, this time around, I would imagine that they'll be thoroughly prepped for trial. And also, hey, this is what the Commonwealth is going to come at you with. And so, whatever your testimony is, it is what it is, but be prepared.
Yeah. Nan, follow up on this one. How
The
do you think the AI did on defense strengths?
It nailed it. I mean,
think
if you
pretty good.
you attack the investigation, which is the most important part of this case beyond the there was no collision. Okay, because to get to there was no collision, that's just we call that a net opinion. You have to prove, not that they have a burden to prove it, but you have to prove through effective expert cross-examination, which was the other topic on that slide, that there was no collision, or that what happened could not have caused those injuries. Attack the police investigation and missteps. And then when you circle through everything, you just have an effective narrative that you weave throughout the tapestry of the Commonwealth's case in chief. By doing that, starting the weaving of the defense story. Again, they got no burden, but they're weaving their way through effective cross-examination. And in addition to their opening statements, now they're going to get to the defense case in chief, and everything is going to start, like, the synapses are going to start connecting. They're going to start firing. You're going to start seeing jurors, and people will probably report that they do perk up, because not only are the defense lawyers more engaging, but they'll also realize, oh, okay, I heard something about that. Or, oh, I've wanted to see Michael Proctor. Where has he been? Or, yeah, I was wondering why we didn't see the Alberts. All of those little weaves will then become the fabric of Karen's defense.
Yeah.
So I do think AI nailed this one. I might start using it in the future.
All right, let's go to this. Commonwealth weaknesses. Excuse me. The burden of proof. The prosecution must prove beyond a reasonable doubt that Karen Reed backed into John O'Keefe with her, Lexus, and left him to die, and had the motive opportunity. That's a high bar of the physical evidence, doesn't definitively prove the chain of events. We have the flat presentation. Hank Brennan has tried to be more dynamic than Adam Lally was in the first trial, but some critics have still described his opening as a coma and said that the case has not yet been tied together in a way that feels conclusive. And then problematic witnesses. Witnesses like Proctor hurt the prosecution's credibility. Even Brennan avoids directly using him. The defense keeps dragging the baggage back in. I like that. All right, let's go here. Challenges in judicial scrutiny. And I love this photo that I made through AI today of Arca just resting on the shoulder of Hank Brennan. And we have challenges in judicial scrutiny. The defense has faced criticism from the court. And this is obviously sourced from Boston 25 News. Judge Beverly Canone admonishes the defense for repetitive misrepresentations regarding the relationship with the experts from ARCA, a crash reconstruction firm. Despite these admonishments, the judge allowed the defense team to remain intact, though the credibility of the expert witnesses may be under increased scrutiny. And we have the jury perspective. From a jury's point of view, even if they don't fully buy the defense's conspiracy theory and only need to believe that something doesn't add up to acquit Reed, so far the defense has given them enough inconsistencies, alternative timelines, and expert opinions to hang onto that doubt. I'm going to go to Nan first. What do you think, Nan? You think AI nailed this or what?
They did. I mean, when I was reading the top half of that slide, I felt like that was a little bit more tailored to trial 1.0. I was like, this sounds like 1.0. However, I think it was pretty accurate. As far as the judicial touch on this case, the jury doesn't get to see how this sausage was made. They don't realize, like, all of what I perceive to be really bad judicial rulings have been entered along the way. In fact, what they get to see are a few things from the judge. One, that she's like saccharine sweet, like, good morning, how are you? Okay, this is why we take this many side buys. We're trying to save you time in the long run. And they get to see that, and then they get to see the fact that questions get asked, objections get raised. She either sustains them or overrules them, or steps in and asks the questions herself. They don't really get to see much of her, and they don't know how, in my opinion, she's wrecked this case and made it just more of a challenge for Karen. From the jury's perspective, I am very comfortable saying, in looking at their facial expressions on a really boring day of court, where I sat through Isaac Wolf and the balance of Christina Hanley's testimony, they seem bored, but they seem very interested in how the defense is asking the questions and what the defense is getting at. So I think all in all, I'm predicting it. I think they're going to
Mm,
acquit her. I do.
mm.
I'll eat crow if I'm wrong.
Go ahead, Todd. Any follow up here?
Just that, this time around with the trial, it's completely different than 1.0. There's a different feel, different style, different strategies, of course. But if the defense just focuses on reasonable doubt, they've got overwhelming evidence and testimony that lands on reasonable doubt. The third party, theory, okay, they put it out there, it was in their opening, but they don't need it. I feel as if sometimes they're working twice as hard, trying to bring that aspect of their defense forward. So they've got a lot to work with. ChatGPT did well on this one as well, but it's just my thoughts.
All right. Well, let's end with this slide here. And it says conclusion. AI says conclusion. The defense leads for now. If the trial ended today, Karen Read's defense has done a better job of creating reasonable doubt than the Commonwealth has done to proving guilt. It says, but it's not over. The prosecution still has time to reinforce their case and deliver a compelling narrative in closing arguments. Unless they do, the defense likely walks away with the win. And I like those odds. I like those odds. So yeah, that was just a fun little experiment here and trying something different. And I thought it worked out pretty well.
It did.
Yeah, I agree. That was fun. I will say though that I don't think that the Commonwealth has even proven that there was an accident. Not only how did
Nan,
it
I'm
happen?
still waiting, Nan.
Yeah, I need to hear there was an accident, and Welcher's coming in. Okay. Let's hear what he has to say. His company took a major hit last week with its contractor or employee Burgess, but I need to hear that there was an accident. I need the Commonwealth to tie Karen to the precise timing of that accident, all of which has been debunked previously through Whiffen. I have heard people saying, oh, the data is clearly showing he wasn't in the house, but even Whiffen said, yes, he could have been in the house. So I need the Commonwealth to, if this is going to be a real honorable fight, which it's not, then there needs to be, oh, that's great, Brian.
Yeah.
Then there needs to be some showing that there was an accident, that Karen caused the accident, that it caused the injuries that were sustained by John O'Keefe, and none of that has been proven. And if I were Brennan, I would be sweating right now on a Memorial Day night saying, how the hell am I going to pull this together with just a few more witnesses to go? What's not too late is for him to decide, you know what, I better call more witnesses because I haven't met my burden. That would have been a smart decision.